Everyone. My name is Andrew Tomko. I am one of the residential underwriting attorneys with Chicago Title and Woodland Title. Today, I'd like to just take a few moments to go over what title insurance is, what an affiliated business arrangement disclosure statement is, and also some of our specific compliance requirements depending on how your client may hold title to the property. First off, what is title insurance? Everyone has a checklist of things when they're looking to purchase a home, but I think a lot of people forget to think about the property's history. Liens, easements, encroachments may all present issues over who may have rights to the property. The last thing that a homeowner wants is a conflict between the neighbors or others as to rights to the property. Title insurance confirms that there's no disputes over who has these rights. Unlike auto, home, or health, where you pay a premium after an event happens, you pay for title insurance upfront to protect you from future claims. By the time you're ready to close on your deal, title insurance provides you and your lender peace of mind that any disputes or restrictions are resolved or at least known to all of the parties. Title insurance is a form of indemnity insurance. It protects the holder from financial loss sustained from defects in a title of the property. Title insurance can compensate you for damages or legal costs in a variety of different scenarios. So it's important that as new agents, we consider to possibly use Woodland Title for your preferred title company, or at least if you have a question about title insurance, to contact Jennifer Evans or myself so that we can guide you through the process. Secondly, what is an ABA? An ABA is an affiliate business arrangement disclosure statement. The ABA is typically a one-page document that generally discloses to a consumer the agent and the nature of their relationship with an affiliated company. This document is required by our title company and is often included when submitting the purchase agreement to our company to begin the process. It's imperative that these two documents, along with any addendums, are submitted to our title company to accurately and efficiently process your order. Again, just to recap, we need to make sure that we have our purchase agreement, any addendums, and of course, the ABA. Next, I'd like to go through some specific title requirements that we have that each of your customers may encounter. And if you do hear of these issues, please let us know as soon as possible so that we can help you work through these issues with your customer. First, board of revisions tax foreclosures. It's important to understand if your client owns property or is purchasing a property that may be impacted by one of these board of revision cases. Currently, a case is pending before the Supreme Court of Ohio challenging the constitutionality of the Board of Revision tax foreclosure proceeding, brought pursuant to Ohio Revised Code Section 323.65. The case is titled The State of Ohio, Elliott G. Feltner v. Cuyahoga County Board of Revision, case number 2019-1307. Once a decision's been rendered in this Supreme Court case, we will be able to determine whether or not we can insure this particular type of title for your customer. Please note that these only apply to Board of Revision tax foreclosure cases. They're not to be confused with a tax lien foreclosure brought by a private investor or additional foreclosure actions brought by the county or municipality. Again, please let us know and we can always see if there are ways that we can make your deal work and accommodate your customer. Next, marijuana, hemp, and CBD. If you have a client that is possibly owning or selling a property that is impacted by marijuana, hemp, or CBD, it's important to note that we may not be able to insure that transaction. Due to the conflict between federal and state laws concerning the cultivation, distribution, manufacture, or sale of marijuana, the company is unable to close or insure these transactions involving land that is associated with those specific activities. Importantly, we don't want to learn this at closing that the land is used or intended to be used for these purposes and then have to decline to insure at that point. So, point be taken that in letting us know soon and very early on in the process can help make sure that your customers know whether or not this specific title can be insured by Woodland Title. Next, hemp. Our company is willing to insure land containing hemp facilities if those facilities exist legally under both state and federal law and have received the requisite permits or licenses from both state and local authorities. We are receiving a number of requests for a position on insuring land used for the cultivation, distribution, manufacture, and sale of hemp or hemp derivatives. As such, land currently used to cultivate hemp under a pre-existing license issued in accordance with the 2014 Farm Bill is acceptable, as well as land that obtains a state or federal license under the 2018 Farm Bill regulations. Long story short, if it's hemp, we are more than likely able to insure your transaction. Next, CBD. The company is willing to insure title to land containing retail establishments that market hemp-derived products such as CBD. Under the 2018 Farm Bill, CBD is legal if and only if it's derived from a hemp produced in a manner consistent with the Farm Bill, associated state and federal regulations, and by a licensed grower. All other CBD produced in any other setting remains a Schedule I substance under federal law and is illegal. Any clients that have title to property that may involve CBD, it's important to let us know so that we can specifically address whether or not we'll be able to insure that property. Next, I'd like to talk a little bit about authority guidelines for different entities in a transaction. Often, when you're dealing with a business, we'll be looking for that business to have good standing here in the state of Ohio. Specifically, we'll review the entire filing with the state, and if there's been a recent change that adds or deletes parties with authority, we have to independently verify the current parties that have that authority. Often, the attorney representing that entity can verify those recent changes. In addition, we'll need to look at capacity. All signatures on instruments that we're relying on, including indemnities and the notary or acknowledgement blocks, need to properly reflect the authority or capacity of the signer. For example, when we're reviewing documents for titles that are owned by a business, we need to make sure that the business specifically states the capacity in which that person is acting. For example, ABC Corporation by John Smith, Vice President. Here we know that John Smith is specifically authorized as Vice President to act on behalf of the business. Next, we need to make sure that we also look at self-dealing and that transactions are conducted with an arm's length, meaning that every transaction Woodland Title will examine and determine to make sure there's no conveyancing or mortgaging of land to an officer of a corporation, partner of a partnership, or member of an LLC, or specific parties to a trust. We always want to make sure that we don't involve any transactions where self-dealing may rise and create an issue for your clients or our customers. Another area of concern is foreign executions. When directors or other entity officials are not located in the United States, all signatures on any documentation, including corporate resolutions, are to be acknowledged pursuant to any of the notarial guidelines for that state and compliance with the terms of the Hague Convention, if appropriate. The last two topics I'd like to briefly touch on are corporations and limited liability companies. Specifically for corporations, we're looking at whether or not we have a copy of the corporate bylaws. If a corporation is selling less than or substantially all of its assets, we must have a resolution from the board of directors adopted at a meeting called pursuant to the corporation's bylaws approving of this transaction. When relying on the board of directors' resolutions, we must have a certified copy of the resolution, confirm that the details of the transaction are spelled out, such as sales price, mortgage amount, relevant terms, and determine who has been authorized to sign on behalf of the corporation. We have to consider state statutes and make sure that any limitations that are indicated do not prevent us from insuring that specific title. Finally, limited liability companies. Limited liability companies require us to review the operating agreement for that specific business. The operating agreement often defines in specific provisions who can act on behalf of the limited liability company. Generally, the managing member of a limited liability company is an agent of the limited liability company for the purpose of carrying on the ordinary usual course of business. An act of a managing member which is not apparently for the carrying on of the business of an LLC in the usual way does not bind the LLC unless it's authorized by any of the other members. execution by a managing member of a deed in lieu foreclosure without the consent of all members, execution of a mortgage involving cross-collateralization with different borrowers, or transactions where the LLC or its property is rolled up, merged, or contributed or converted to another entity, all can raise substantial red flags from a title insurance perspective. Again, we really appreciate everyone and all of the hard work that our customers and agents are doing. And anytime that you or any of your customers have a specific question when it comes to title insurance or whether or not we can provide that, please let Jennifer Evans or myself know over at Woodland Title. We're happy and committed to our team and excited to make sure that your guys' deals work. Thank you all so much.